Module 3. The topic is involved. The liability that you as a server can be accountable for. Information to be covered in this unit. Number 1. Rights, responsibilities, and liabilities that apply to you. Number 2. Types of liability against you. Number 3. What you can be sued for. Number 4. Damages you might have to pay. Number 5. Criminal liability. Number 6. Using the logbook. And number 7. Alcohol serving policy. Laws and liability. This is what the ABC website says. As a person who works in a licensed business, there are a number of rights, responsibilities, and liabilities that apply to you. Rights are actions that you can choose to take in the responsible running of your business. Many of them are specified in the law, such as Business and Professions Code and Government Code. As an example, you have the right to refuse service if someone fails to show you adequate ID. Responsibilities are actions that you must take under specified circumstances. Again, many of them are spelled out in the law. Liability occurs when you are held responsible for injury and damage that either occurs to your patrons or is caused by them. Some forms of liability are specified in the law. This is known as statutory liability. Other forms evolve through common law, a set of principles that guide the lane of responsibility in any specific case. This training is designed to give you skills and knowledge to help you avoid breaking the law and reduce your risk of liability. The purpose of penalties is not punishment, but to deter licensees using license privileges in ways contrary to law that puts the community's health, safety, and welfare at risk. Penalties include the suspension of license privileges, the imposition of conditions, and revocation of license. Licensees are strictly liable for all activities that occur at the licensed business and for the acts of their agents, known as employees. Just a reminder, you can refuse service to anyone except for these reasons: race, color, gender, religion, ancestry, disability, or marital status. Types of liability. Liability occurs when you are held responsible for injury and damage that either occurs to your patrons or is caused by them. This could include injury and damage from things such as slips and falls, fights, or drunk driving collisions. The liability of licensees and their employees falls into 3 areas of law: criminal, administrative, and civil. One situation that could potentially result in all 3 types of liability is the sale of alcohol to a minor. Types of liability. Criminal. The arena would be the courts. The results would be a fine, community service, jail. Administrative. The arena would be the ABC. Results: fine, suspension, revocation. Type of liability: civil. The arena would be a lawsuit. The results could be money, a judgment against you. Criminal liability. Court against the server. Individual seller servers are held responsible for crime observed by law enforcement officers. The penalties could be a fine, community service, or jail. Administrative liability. The ABC against the licensee. Fines would range from $750 to $20,000. Suspension of the liquor license. Revocation of the liquor license. Licensee may accept penalty recommendations or request a hearing. Penalties are decided on a case-by-case basis. The type of violation, facts of the case, and licensee's past record are taken into account. Administrative disciplinary action that protects the public, welfare, and morals. Civil liability. A lawsuit against everyone. Statutory civil liability. Civil liability refers to the potential civil legal liability of licensees and their sellers/servers for injuries caused by their intoxicated patrons. Section 25602.1 of the Business and Professions Code defines statutory civil liability in California. Under the statute, liability exists only when the patron was obviously intoxicated and under age 21 at the time of the sale or service of an alcoholic beverage. Common law, duties of care. Under common law, a licensee has a duty to exercise reasonable care for the safety of his or her patrons. When a licensee is negligent in exercising reasonable care, an aggrieved party may file a common law action in court and civil damages may result. Therefore, if the service of alcohol is negligent, common law liability may result under common law duties of care regardless of the customer's age. Reckless conduct may also give rise to a lawsuit under common law. Reckless conduct goes beyond mere negligence. Reckless conduct is when a person has intentionally done an act of an unreasonable character, has disregarded risk that he or she knew or should have known, and it was highly probable that harm would follow. It is usually accompanied by a conscious indifference to the consequences. If the service of alcohol can be characterized as reckless, the drinker, whether minor or an adult, can recover for self-inflicted injuries, or at a minimum, not bar a wrongful death suit by his or her beneficiaries. California does not have dram shop laws, also known as third-party liability lawsuits. Some states do. A third-party alcohol liability lawsuit is when a guest is overserved alcohol and causes damages of any kind. The person or persons who suffered damages can sue the persons and establishment that supplied the alcoholic beverages that were consumed, causing the intoxication. But California law does allow the lawsuit to commence if a minor was served alcohol and caused damages, and an establishment can be liable for damages caused by its customers in other situations. If another customer warns the establishment, owner and/or employees of danger, but they fail to cut the drinker off, the law could hold them liable. If the establishment allowed a person on the premises whom they knew had a predisposition for causing trouble, or let a fight continue longer than they reasonably should have, the court may also hold the establishment liable. Here's an example. An establishment serves a minor to the point of intoxication. The minor leaves the establishment, drives off, and hits a pedestrian, injuring them. The pedestrian who suffered injuries can sue the minor who was drinking in the establishment who served the minor. This also goes further. An establishment can be held liable for damages caused by its employees breaking the law which causes injuries. This is a true case that happened here in California. After the employee got off shift, the employee drank to the point of intoxication. When they drove off, they hit a skateboarder with their car. The injured party sued for damages, claiming the restaurant was negligent about its rules regarding drinking on the job. Although the employee was technically no longer on his shift, the establishment lost the case and paid over $1,546,618 in damages to the injured party. The restaurant was found guilty of negligence since the owners permitted and encouraged employees to drink after they were done working. The establishment benefited from its employees drinking at the restaurant despite knowing the employee would be driving. And what are the potential legal consequences of breaking a California ABC law? Criminal liability. If convicted, you will have to pay fines or you could go to jail. A minimum $1,000 fine and 24 hours of community service. If a person buys alcohol and furnishes it to a minor who consumes it and causes great bodily injury or death to himself or others, the furnisher faces a minimum 6 to 12 months in county jail and a $1,000 fine. Administrative liability. ABC against the licensee. Fines. They range from $750 to $20,000. Suspension of license. Revocation of license. Civil liability. A lawsuit against everyone. You lose your home, your life savings, and whatever else you've accumulated. The licensee consequences are relatively straightforward. If you're caught, you lose your license. The civil consequences require more in-depth treatment. When looking at the civil consequences, there are a few specific questions you need to ask. Who can sue me? What types of damages will I have to pay? What can I be sued for?